What is the impact of MIIX's insolvency, and what should you be made aware of? The first thing that you should be aware of is the most important case regarding insolvent insurance carriers in the state of New Jersey. That case is called Johnson versus Brady, and that was held by the New Jersey Supreme Court in 2006. In that case, the Supreme Court decided that if an insured buys a policy from an insurance carrier that eventually goes out of business, or what we term insolvency, that policyholder will only be protected up to $300,000, which is afforded by the state's guarantee fund. Outside of $300,000, a physician or any policyholder in any line of insurance is personally liable for everything beyond that $300,000. Now, keep in mind that there is no homestead exemption in the state of New Jersey. Therefore, as a physician, if you're involved in a medical malpractice lawsuit and that verdict is above $300,000 or a settlement's above $300,000, your personal assets, your house, the equity in your cars and your house are all subject to being lost in that verdict. This underscores the reasons why physicians need to do their own independent research, because ultimately, it's your assets at risk if an insurance carrier goes insolvent while you're with them. Another very important case for physicians to be aware of in light of the MIIX insolvency is a case called Carter Lincoln Mercury versus EMAR Group, which was held in 1994. In that Supreme Court case, the Supreme Court stated that brokers should perform reasonable investigation into the insurance carrier in which they intend to place an insured's policy. And if, at the very minimal, they find that the insurance carrier has financial conditions that are maybe adverse to the policyholder, they should either make that policyholder aware of it or prevent that policyholder from purchasing a policy from that carrier. The reason why that's important is because looking at MIIX's AM Best rating history, if you were a policyholder with MIIX in 2002 and your agent or broker failed to tell you that MIIX was experiencing significant financial deteriorations in terms of its rating history with AM Best, and a claim occurred anywhere from February of 2002 to September when they went out of business, you could have a case to support that your agent or broker breached their fiduciary duties not only to you, but also the foreseeable people in which their negligence had impacted, which could be the actual patients themselves. Now, in summary, MIIX's insolvency taught us several things. Number one, asset protection should be planned now before any litigation is contemplated. The reason why is any transfer of your assets after you believe that litigation is about to ensue is going to be considered an invalid transfer, similar to if you were to get separated from your spouse. Now, patterns also that we need to be aware of due to MIIX's insolvency is an AM Best financial rating history, which goes from an A- or a favorable rating to a not rated at the company's request. These are obvious signs to physicians that there are financial difficulties being experienced by an insurance carrier. Otherwise, the fundamental question must be asked, why wouldn't they publish a rating if they were rated favorably before? The third thing that we've learned was that cost should not be measured in what you pay every year for premiums alone, because the ultimate cost may be all of your assets. We also learned that physicians should be aware of the fact if they're buying a policy from a new type of insurance company called a risk retention group, that risk retention groups do not even give them $300,000 worth of coverage by the state of New Jersey, which means that if that carrier goes out of business, physicians will start losing money of their personal assets from dollar one. Finally, physicians should not rely solely upon their agent or broker, but should do independent research of their insurance carriers through some of the 4 tests that we outlined in our previous video series. This concludes our section on MIIX's insolvency. You'll learn more about risk retention groups and binding arbitration in our next video series.